Well, folks, I am sorry about that long delay there. We are on a bit of a lag here. For some reason, it's a little bit longer than normal. So I apologize for that delay, and I'm sorry you had to look at me staring intently at my screen. So, in any event, we are here again today. This is episode 12 of the Veterans Law Blog video livecast. So this is the 12th time we've done this. It's really a lot of fun for me. It's going to be a lot of work, so I might do it every other Friday from now on. We'll see how that goes. I'd like to keep it every Friday, but it's getting to be a lot of work. So we'll see how it goes, but in any event, we're going to keep doing it. You guys like it. I like it. Let's keep at it. So for those of you that are new here, what is the Veterans Law Blog? Veterans Law Blog is, my goal is to make it the best resource for veterans battling the VA. Simply said, that's all it is. It's a member-supported website, and what that means is that we're able to get all this material to you thanks to the support of premium members to the site. So how did this thing start? 10 years ago, I started working with a few vets by email, kind of taught them some of the things I was learning as I was learning the ropes as an attorney handling these claims, and they started getting back to me and telling me that they were having great success. So we took it to a blog and started teaching more vets how to do this on a blog. That really was having the same results. I was starting to hear from more and more vets that were finding big and small successes based on what they learned on that blog. And so what we did is I started publishing more in-depth information in ebook fashion. And as with all things so far, that continued to get more and more popular, and more folks were using that, getting out of the VA hamster wheel faster, and so then we started doing some video training. Well, all of that just became a lot of expenses and overhead. So for several years, I fronted the cost of this myself, but now it's to the point where it's super expensive to keep this thing running each month. And so we went to a premium membership format, member supported. So you can support this by joining and becoming a member. When you become a member, you do get certain perks. You get access to thousands of the posts from the Veterans Law Blog, some of them going back 10 or 11 years. We try to keep them updated, so I have a regular cycle that I go through these posts to keep the law current, so you don't got to worry about that. But there's a good, pretty significant library of old written posts. There's some video blog posts on there too on things like how to file and how to walk through a VA ratings decision, a walkthrough of a statement of the case, several walkthrough videos like that. We've got video training up there. You get access to the searchable database where you can search by topic, you can search by claim type, you can search by medical condition. Premium members get a 20% discount off of any other purchase, whether it's a webinar, an ebook, a training video, whatever the case may be. Premium members actually get into those webinars for free as long as they get in early enough. So when we do these webinars, and I'm going to tell you about our February webinar that's going on next week in just a minute here, but the premium members get the first crack at free seats. So that's one of the perks. But all other stuff, premium members get a 20% discount they can use anytime, as often as they want on any other purchases. So it's a pretty good deal. We're adding some new things here. Talked about the podcast. I'm not going to go into a lot of depth on that here. That's cooking right along and hoping to release that in early April. I want to tell you, I got an email this week from a Marine Corps veteran, 20-year Marine Corps veteran who then went into law enforcement for 25 years. And I'm not going to tell you how big his success was because that's personal, but Stephen S. is his name. He gave me permission to tell his story. So he's been working on this appeal, and he got all the way up to the BVA hearing level, had no success working on his own. So he read some of the stuff on the blog, and he said, I requested an in-person hearing before the BVA judge so that I could use some extra time to prepare and use your blog to learn more. I followed your recommendations. I put together a case folder with a brief synopsis for the judge and medical evidence. Long story short, the judge was impressed and opined that she wishes veterans would do the same as I did. He then told the judge about the Veterans Law Blog and that he was a member, and he said that the judge smiled at him and says, well, that doesn't surprise me. So we are pretty well known inside of the BVA, and so a lot of judges, and they expressed to this particular veteran that they appreciated the organization. He got that organization from the blog and frankly, from some of his old skills. I mean, you guys still have to do all the work. I'm just going to teach you how to do it on the blog. And his parting words to me was that the judge granted his diabetes, a service-connected, remanded another claim back to the RO for some more development. He said, "Chris, you made things so clear for me via these ebooks and posts. Thank you. What's important is the type of information presented and the manner in which you present it, and you made that possible and easy for me. Thanks, Chris." And so his name was Stephen S., Marine Corps veteran, 20 years. Just a huge congratulations to him. I know that no matter what you learn on this blog, you are still the one doing the work in your case. And when you get all the way through and you get service-connected 100% and you get 5, 10, 15, 20 years of past due benefits, that's your hard work. I just gave you some knowledge. You still had to roll up your sleeves and do it. But in any event, I thank all the premium members who have joined and who support this enterprise, this thing to keep going. Continues to allow me to get more and more information out there to everybody. So, and I will tell you, just for the record, I've said this probably every single one of our episodes, I'm not in this to get rich. If I wanted to get rich, I would run for Congress. What the funds go to pay for is things like the servers where we host content. Video content can be really incredible. I'm going to tell you, we take this video down, we put it up on the site, and we stream it there forever so that premium members can have access to every one of these videos for all time. So that starts to get expensive over time. Webinars get expensive. A lot of the other resources that we need to keep this site secure and to keep it up and available can get really expensive. So all of that money from premium memberships goes right back into the blog. And we're hoping to get some folks in here. I've been working, one of my big battles that I've been fighting is getting premium members priority support. But it always seems like something comes up with somebody having to go into the hospital or a big deadline in a case or whatever the case may be. And so I always find myself getting behind. So I am working very slowly to find somebody to help me with that. I'm really picky about who I work with. And so I'm taking my time to find the right person that can help me with some customer support. But I want you all to know that I'm working on that. I'm about 5 to 7 days behind getting to your emails. But I will get to all of them. If you're a premium member, I guarantee I will get to all of them. And then I'll start working through the rest on a time available basis. So, in any event, that's enough of the administrative stuff. What is this live cast all about? So listen, the way we usually do it, we're going to do it a little different today. But the way we usually do it is I have a segment at the beginning where I go through some news and announcements. It's not veteran news, it's VA benefits news. So the sort of things that are going on behind the scenes at the VA, behind the scenes on Capitol Hill, not as they affect all veterans issues. That's just simply overwhelming and too much information, but as they relate to veterans benefits topics. So after the news segment, then we're going to go into what I call the main topic. The main topic is a real in-depth study of a particular issue, a particular type of claim, a particular area of the law, a particular procedural step or form or document where I'm going to walk you through in pretty good detail how to handle that situation. And today our main topic is the benefit of the doubt doctrine, or reasonable doubt doctrine as it's sometimes called. We're going to talk about that. And then we go into a segment where I answer your questions. Now, it's always been a dream of mine to be able to do a live Q&A where we can actually have like a little window pop up over here. And, oh, that's a really bright light there. In any event, I'm like a raccoon sometimes. I see something shiny and I get distracted. But in any event, I've always wanted to have a live interaction where I can answer your questions live. The technology is not quite there for us yet. But I am working to find ways. But until then, what you can do is submit your questions to veteranslawblog.org/Facebook Live. And there's a form there you can fill out and ask your question. I go through every one of those questions every single week. And what I'm looking for are common questions. Because if a lot of veterans and a lot of survivors are asking the same types of questions, then I know there's an opportunity to really impact the learning for a lot of y'all. And that's what I'm looking for. So get in there, ask your question, ask many questions. It's not just a one and out kind of a deal. You can get in there and ask 10 questions. I'm going to read a lot. Attorneys do that. That's all we do anymore is read, read, read. So I'm used to it. Don't worry about me. If you've got a lot of questions, submit them. It's helpful if you submit one question at a time. That way I can kind of sort them into my folders and keep track of the different topics. But in any event, at the end of this, for all of you that can stick through it, we usually go anywhere between an hour and 15 minutes. I think our last one was getting close to 2 hours. I don't think we're going to go that long today. We're certainly going to get up to an hour, though. If you make it all the way through to the end, then I'm going to give you this week's coupon code or special that you can use for a particular purchase on the blog. So again, my goal is not to get rich here. as I have the opportunity, as we get caught up on the expenses and everything, I have an opportunity to knock a price down here or there. And so I try to do that every single week. And I go based on popularity, what folks say they need the most. When folks are telling me, hey, could you offer a discount on this? Send that information to me. Use that Facebook Live form to send that to me, because I really do pay attention to that and try to get those discounts lined up to what y'all are saying you need. My goal here is not to put anybody in the poorhouse. My goal is to keep this project going, and every year the costs go up. So after the video is over, I record this as it's going on, and after it's over, we download it, and then it stays live on Facebook. Now, at some point here, I'm going to have to take some of the older shows off Facebook, just because it's starting to get to be a pretty big video streaming demand, and I'm a little bit worried that Facebook's going to, come and ask me to open up the checkbook again. So we're probably going to pull some of that down. They probably won't do that. I hope not, but I always get nervous about that. In any event, they are always available on the Veterans Law Blog. If you go over to that maroon menu that's on the right-hand side as you're looking at the screen, you'll see a series of topics with little plus signs next to it. Click on those and it'll expand into an accordion, and then you can click on each of those subtopics and it will take you to that topic. We'll go all the way to the bottom and look for the Facebook Live links, and then you can look at, right now we've got episodes 1 through 12, and that's going to end our first season. We're going to start over with our second season, do some different things a little bit here in a couple of weeks. But this video will be available on Facebook for several weeks. This video will always be available, on the Veterans Law Blog, and I do make it available on YouTube as a recorded version. Any topics or links that I mention are in the show notes, which is the first comment below this video and Facebook, or if you're looking at this on the website or the veteranslawblog.org website, just look down below the video and you'll see links to everything. Now, if you're on YouTube watching this, you're not going to see any links. YouTube and I have gone around and around and around on putting links into the comments and description section, and they get really hacked when I do that. They think I'm trying to scam their system and trying to get search engine rankings, and frankly, it really does make it hard for folks to click through those. So with discussions with YouTube to try to change that, it's just easier to go with their general policy, which is no links in the description. So if you're watching this on YouTube, you got to come to the blog, or you got to pop over to Facebook. So in any event, I think that's everything we need to know. Today's topic, as I mentioned, is going to be the reasonable doubt doctrine. I am not doing any questions today, but what I am doing is I am going to go into a second topic in depth, and there's a reason for that. So over the last month or so, we've been getting a lot of questions from survivors asking me, saying, hey, the VA told me this, or a VSO told me this, is this true? So what I've done is I've taken all of the myths that they tell survivors of veterans, and the big ones that everybody gets told almost all the time, it seems, and we're going to walk through those one by one, and I'm going to debunk those myths, because every single one of them is nonsense. And every single one of them keeps a veteran survivor from getting benefits that they're entitled to. So instead of taking questions, what we're going to do is we're going to have a second topic based on a lot of questions that survivors have asked. So a couple of things before we jump into the news segment. I want to tell you, where's my notes here? And I got to defer to my notes on this. We are doing a webinar Tuesday. Is our second webinar. What is a webinar? It's this format right here, where it's actually in a different format. It's not live and open on Facebook. It's in a private forum where you have an opportunity to get training from me directly, real in-depth training on particular topics, and ask me live questions by typing them in. What we do is this webinar coming up, you can access it anywhere you have internet access. And we'll watch along, and if you miss it, then you get a recorded copy afterwards. So it's kind of a cool concept. But in any event, we've got our second webinar on Tuesday, February 28th at 10 a.m. Central Time. We're looking at probably a 3-hour session, and what I'm going to teach is how to prove the 4 pillars of a VA service connection claim. We are going to walk through a ton of stuff, and actually these courses are the same courses that I use to train attorneys and advocates when I teach them how to do this. So you're getting some real important information, some real high-level stuff here, and we're going to spend some time on it, because what I'm seeing is that when you guys get the knowledge of how to approach these claims in a more organized and structured fashion, there's no stopping you. There's no stopping you. You do amazing things with that. And so I want to give you this in-depth information. We had one ebook called The 5 Paths to Service Connection. We've taken that ebook down and we have consolidated it and expanded it in some ways, in a lot of ways actually, to cover this what I'm calling the 4 pillars webinar. So we're going to talk about what you need to prove to show that you're eligible for veterans benefits, the difference between military reserve duty, the types of military service and how they affect eligibility, drugs, alcohol, tobacco, how all those things, line of duty investigations, how they affect eligibility. We're going to talk about the building a bridge to service connection. How do you do it? How do you prove that second pillar? How do you prove the disability? How do you prove the nexus? And how do you make the connection in such a way that you're not going to get denied and have to get appealed? We're going to talk through all 5 different paths to service connection. I'm going to teach you the presumption of soundness. I'm going to teach you the presumption of aggravation. And then we're going to move into pillar 3. I'm going to teach you basic impairment rating principles. I'm going to teach you how to prove up the right impairment ratings. We're going to learn how to use Table 4, which is the schedule of impairment ratings. I'm going to teach you about analogous ratings, combined ratings, bilateral ratings, staged ratings. I'm going to teach you about several different kinds of ratings that not many folks out there know about. We're going to talk about pyramid ratings. We're going to talk about residual ratings, aggravation ratings, amputation factor, medication rules, all these different rating rules. And then we're going to go into pillar 4 where we're going to talk about effective dates. We're going to hit the general effective date rule pretty intensely because it's pretty important. You can work that rule in several ways to get an earlier effective date. We're going to touch on some of the NEMR effective date rules, but I'm not going to go into depth on those because those are really confusing. We're going to have a whole separate section another day for NEMR. And frankly, I'm holding off on that for a little bit because I think that we're probably going to see a change here pretty soon. But in any event, we're also going to go into some add-on stuff at the end. I'm going to teach you 4 ways to maximize your rating. I'm going to teach you some of the basic concepts of special monthly comp and TDIU because those are 2 ways that you can increase your rating. We're not going to go through all 6 million kinds of special monthly comp. Simply that would probably take closer to 3 months for a webinar. Special monthly comp is complicated, but we're going to hit the most common ones, going to familiarize you with the concept to lay the groundwork to coming back to it later. And then we're going to talk very briefly about TDIU because that's a pretty significant way to get your rating up to 100%, and there's more ways to do it than what the VA is telling you. So it's going to be a pretty significant webinar. It's a lot of information. You know, in the Army they used to say that you should never talk longer than what your butt can stand. I guess your butt could sit, theoretically. So basically the rule of thumb was never have a class longer than 45 minutes. But the advantage we have here is that we're recording it, and I can talk a long time. As long as I got a cup of coffee and a glass of water, I can talk a lot. And so we're going to go through these step by step by step. We're going to rhythmically attack each of these 4 pillars, learn how to prove them up in your case. And then if you get worn out in the middle, don't worry, drop out. Because what happens if you bought a seat to the live webinar, within a couple of days or a few days after the webinar, we download that video, we clean it up, we shorten down the segments into separate courses, and then we load that up into your Veterans Law Blog account dashboard for free so that you then have access to it recorded as long as you want. So it's a pretty cool concept. You can come back and watch it as many times as you want, whenever you want, as long as you've got an internet connection. And frankly, there's ways to access these streaming videos on the blog even if you don't have an internet connection. You can just, in most cases, you can just download them to your computer as long as it's a laptop and you can take it with you on a plane. Then that's one way to do it. Not all of the videos will allow you to do that. Not all the browsers do. So the blog doesn't play very well with Firefox. Frankly, I don't think very many people do anymore, but it's too bad. It's a great browser, but in any event, the blog doesn't play well with it, so I recommend you not use that, and I don't think you can download videos on that browser, but in any event, way too much information about downloading videos, but listen, I want to let you know, so here's how webinars work. I tell the folks that I want this many seats, and the folks that are hosting it, setting up the video, streaming, setting up all the information, and then they price it out based on how many seats I think we're going to fill. And so they quote me a price. And if I fill that number of seats, we're good. If I don't, then I've got to pay a penalty price, a little bit higher amount. So we're real close. We had one of our limits that we reached, and we actually got enough people to cross the first limit. And so I am going to keep that sale up through the rest of the weekend. So if you go to, where's my website? hold on, bear with me one second. I know I wrote this down. Oh yeah, go to veteranslawblog.org/4pillars. That webinar is going to be on sale through the rest of this weekend for $49.95. So I think that's probably about 50% off of the price. And you can thank all the folks that got us in and over our threshold early that allow me to keep offering that low price. So in any event, if you are a premium member, I have 2 or 3 free slots left. So just let me know that you're a premium member and I can send you the code so you can get a free seat. But again, I only had 2 or 3 or more of those left. This video will probably be offered on the blog after the webinar, but it may not be for a couple, 2, 3 weeks or longer. So it all just depends on how long the video post-production takes. Anyway, it's going to be a great webinar. We're going to have a great time. We're going to learn some stuff. It's a real fun environment because you can interact directly with me, and I think in some cases, if I allow it in the forum, you can interact with each other, and so it becomes a great learning tool. In any event, today in the news, I want to follow up with you guys on something we started talking about 2 weeks ago. BVA, VA Form 9 dates. What the heck? That's just my notes there. I should not just read directly off my notes. That's just not, that statement made no sense. All right, so BVA docket hearing dates. Board sets these docket dates based on your VA Form 9 date. When you submit your VA Form 9, that's the controlling date for your docket date. And once you get assigned a docket date, then it's in that docket date order that the board sets your hearings. So, why am I telling you this? About 3 to 4 months ago, the board was telling us that they were processing up through, what was the date? Late 2014 VA 9s. They were making some real headway clearing through some appeals backlogs. And then right after the election, and I'm not saying there's a connection at all, I'm just saying this is what happened right after the election, the board's docket date started creeping slowly back. And 2 weeks ago, it was back to February of 2013. Today, I just checked it today, and I think it's November of 2012. So it keeps creeping back. A lot of rationale, a lot of reasons that I've heard floating around. You can go back and watch episode 11, and you can hear some of those reasons. But we heard a new one just a couple of days ago, is that the BVA's bump is because bigger regional offices, and I'm reading, this is a quote from somebody, I can't tell their name, but it's somebody that has the knowledge, that should know what's going on, so I put a lot of stock into this. But bigger regional offices have been taking a while to certify claims to the board, so by the time they get to the board, they're very old and they get bumped to the front of the line. So if that's true, the big regional offices are not following their own rules. As we're going to talk about the M21 a little bit later, the M21 says that as soon as you get that VA 9, you're supposed to certify it to the board. And they're not doing that, or issue a supplemental statement of the case. So they're not doing that. Things are getting held back, and then when they dump these big piles, it pushes everybody back. It becomes an inefficient system. A lot of times the VA wants to blame that and say, we're big regional offices, we're just overwhelmed, and there probably is an element of truth to that. In fact, I think that probably is true. They are overwhelmed, but it's because of more reasons than I can go into here. But it starts with a really crappy process that dates back to the 1950s that has not been updated to match the modern disability compensation type scenario that veterans today and even veterans of the Vietnam era could use to make things go quicker. It's just a clunky old system that, rather than taking the thing and starting a new system that makes sense for what we're doing today, we're just putting Band-Aids on it. So we keep putting on these Band-Aids, and right now what we've got, I don't know how many of you guys are Johnny Cash fans, but we've got the one piece at a time car is essentially what the VA claims process is. Basically, it's, the guy in the song took one piece of a car out of the factory he worked at a day, and then he kind of assembled a car from all those pieces. I actually heard that was a true story. I don't know if there's any truth to that. Maybe somebody out there knows, but that's what I feel like we're doing, is we're just taking one piece and we're plugging it in. Doesn't work, we put another plug on top of it. Doesn't work, we Band-Aid it. Doesn't work, we duct tape it. And pretty soon we've just got this big mess that doesn't work. Anyway, that is what we think is going on with these board docket dates. I am continuing to keep my ear to the ground on this, and I'm talking to a couple of folks. I have a lead on another explanation, and hopefully we'll hit that in a couple of weeks. But that is where we're at on that. So the next thing, I'm going to step out of the screen here. I'm going to pick up something I want to show you. So the VA has this thing called the Evidence Intake Center, and you can get on the blog, search Evidence Intake Center, or look, if you're watching this in the recorded version, scroll down to the show notes and read about the Evidence Intake Center. But it's basically where you are to send all of your claims, all of your evidence, all of your appeals forms to the VA, so it goes into a centralized location and is processed out to the regional offices. It's actually, frankly, I've toured the facilities. It's actually one of the more efficient things that the VA is doing. It's being supervised by VA personnel, but it's being done by outside contractors. So for what it's worth, this is actually a pretty efficient system of getting the claims mail in. And if you send it to this address by mail, and always send certified mail, if you send it in, it gets into your claims file and your digital file in the VBMS system, which is the Veterans Benefits Management System, a lot quicker. It would get there a lot quicker if the VA regional offices could figure out how to more quickly move things out of their mailbox from the Evidence Intake Center, but that's another rant for another day. If you fax into the EIC, it gets in a lot quicker, because what they do is they take these forms that you're sending in and they parse them out and they decide where they've got to go based on the information that's on them. And so to make it easier, they gave us all a fax cover sheet that we can use for claims. Now, there's supposed to be one coming out for appeals, but for right now we've got the one for claims that you put on the front of your packet. I am going to put this on, I don't know how to load it up onto the Facebook site in a way that everybody can get it. I may be able to find the download link on the VA site. It was actually kind of hard to find and had to get some help getting a copy of this form. But in any event, it's definitely going to be in the show notes on the Veterans Law blog. You click on it and you can download the form right away. And it's called the Centralized Intake Cover Sheet. And you put enough information on there. It's effective January 2017. You put enough information on there that it allows the digital sorting process to figure out where this is supposed to go. There's some things that are interesting on this form, and we'll talk about this in a separate blog post, but they've got a series of blocks you can check here in the middle called the emergent claim categories. And some of these are familiar. We know that the VA processes certain types of claims quicker than others. For example, if you have age, this form says 85, it's wrong. 75 or older is what the statute says. The rule of thumb kind of informally has always been if there's a vet 70 years or older, that they're going to move that case a little bit quicker if there's another little hardship that you could show there. So we've known that happens. We know that they move homeless vets up to the top of the line or front of the line. Terminally ill veterans get moved to the front of the line, and a couple of others. But there's some interesting ones here that we haven't necessarily seen before. Suicidal claimants, we haven't seen that. That's very interesting to me. We have also on there veterans seriously injured in service but not in receipt of benefits. That one's going to be a problem because that's 95% of the veterans that I talk to. Except for a few veterans that are out there that are just have smaller scarring claims or smaller hearing loss or tinnitus or smaller foot injuries. Most of the veterans that I see were seriously injured in service, particularly the combat era veterans, but not in receipt of benefits. So I think what they're doing is they're trying to find ways to speed this up, but I think what they're going to do is they're going to start putting these cases into pipelines, and they're going to start triaging and seeing who gets the attention quicker. And I'm a little nervous about federal government bureaucracies doing triaging. So anyway, this form will be up on this is the fax cover sheet for submitting claims related information to the VA. It's going to be up on the Veterans Law blog website. We're going to have a separate post for it very soon, but it will be below this video. There will be a link where you can download it if you're watching it recorded. If you're watching this recorded on Facebook, you got to go to the blog to get it, unless I can figure out some kind of workaround to get this posted as a separate document. I don't want to just take a picture of it because you need the whole form. But in any event, that's kind of a cool update on the news there. What else do we got? Got some interim appointments for personnel on the VBA side of the house. I'm not going to announce them here because I just saw them literally minutes before I came onto this video, and I want to do a little bit more investigation. I did not recognize a couple of the names. I recognized most of them, but I'll tell you about those in a future episode. So last thing, and then we're going to get into the meat of the show, and we're going to talk about the benefit of the doubt doctrine. Listen, The world we live in right now, tempers are flying everywhere. And before we get any further into this discussion, I'm going to tell you this is not a political discussion. The Veterans Law Blog is not political. I don't give a shit if you're a Democrat. I don't give a shit if you're a Republican. I don't care. You're a veteran, you're my brother. You're a veteran, you're my sister. Right? That's all I care about. All that other stuff is meaningless to me. So, having said that, everybody's angry out there. And you see it on Facebook. I'm starting to see it in the real world. The other day, we had a flag show up in our neighborhood that's a symbol of some pretty nasty stuff. We also had some pamphlets show up on our front door for a neo-Nazi organization. So there's some stuff ramping up in the real world that's really concerning, and tempers are flying. I was livid when that thing showed up. My grandfather went over there to kill Nazis, not so that they could come back to our country and poison us with their filth. But that's not political. That's my opinion on Nazis. In any event, that stuff's showing up in our neighborhoods. Everybody's getting mad. It's showing up on Facebook. Everybody's getting mad, and we're yelling and screaming at each other, and it's getting nobody anywhere. So one of the things that I've always talked about on this blog, and you guys know that have been following me a long time, know that I can rant and rave with the best of them, right? Know that I lose my temper just like everybody else does. I lose it with the VA. I've sent my share of letters that I probably should have shredded, and I come to regret them each and every time. That said, I'm not perfect. So take that with a grain of salt, but I try to encourage folks on this blog to be polite and civil inside the VA. Even if it's boiling their blood to do it, say thank you. If you see a bureaucrat that does something for them, even if it's their job, say thank you. Because that makes a lot of a difference. And those folks are doing some work, and they are doing something. If somebody goes out of their way to help you, say thank you. Document it. Send them a thank you note. Honestly, do those things. And you know I've pushed these things. I really want to push some more civility in the veterans community. Something happened here locally. I got online and I posted on my senator's website, our Facebook page, and I got attacked. I got laid in. And I posted about it earlier, but one gentleman called me a pitiful vet because of my views. I'm not even sure. He says he was a vet, but there was another group that told me that they were looking into some things because he's a known troll, so I took it with a grain of salt. I'm not saying he was. I'm not saying anything stolen valor there. I'm just saying there's things being said in the community that he's in about him. But in any event, others ganged onto that, and I saw it in other places too. I've seen friends of mine that have posted, or friends of mine that have been talking at a coffee shop or talking at a restaurant, and somebody starts yelling and screaming at them and calling them names. I'm going to implore you, veteran to veteran, that we lead the way in the culture of civility. And I'm going to take you back in time to a story, to our very first president, and I want to tell you about something that he did. So, through all of humanity, the name of the game is promise people pensions so they join the military, and then when the war's over, screw them. That's just the way it works. I mean, you go all the way back to the Battle of Hastings. You go all the way back to the Roman era, and read how I'm struggling to think of the one battle that comes to mind. That this was actually a whole group of vets were angered about this back in the Roman Empire, as they were promised pensions and they were denied them. Point is, all through history, these struggles exist. Same thing happened in George Washington's time. So here, beginning of our country, some people, farmers, merchants, people risked an awful lot to stand up against the crown of England back in the early mid-1700s. And they were promised some pretty significant land grants and pensions in exchange for doing that. Well, as it turns out, they got screwed. That's the name of the game, folks. If you're promised something to go to war, somebody's fixing to screw you. I'm just telling you, man, we got 2,500 years of history doing that. And I'm sure that before we could write, that back when they were in the caveman, they were, grunting out, I'll give you one big round rock and whatever, and then screwing them out of the rock. It's been happening. It happened after the Revolutionary War. And a group of Revolutionary War vets were hacked and had their fill. They sacrificed a lot, and it's hard to imagine that. Even our soldiers today sacrifice a lot. You know that I believe that. I know that you believe that. But we can't imagine what they sacrificed, because had they lost, they would have all been hung for treason. And that's not necessarily the case here. If our army loses today, we've got some things to figure out, but nobody's going to be hung for treason if we lose, right? They were. And so they had a lot. And so when they were deprived of those pensions, they were pissed. And they started forming these groups of militia together. And one of them was planning a pretty significant coup to overthrow the newborn Congress at the time. I think this was still under the Articles of Confederation before the Constitution. Not 100% sure on that. But in any event, George Washington, they called him and said, hey, George, come on down here. Help us out. You fought with us in all these battles. You led us through all this stuff. There's folks that want you to lead this country. Come on down here and join us. And people will believe you. And maybe the Congress will start paying our pensions. Well, George Washington went down there, and he made a speech that goes down as probably one of the most significant speeches that he's made. But there's a line in it. Basically what he did is he talked them out of the mutiny. He talked them out of the coup. And basically what he said was, and I'm going to tell you a quote here because I think it ties into what I'm trying to say. He basically talked them down by saying, listen, I did fight by your side. I have gray hair. I've lost my vision. I have not gotten my compensation. But we do not win our case. We do not prove our right to that pension by rebelling and overthrowing the government. And what he said, and this quote plays very well in today's culture, because I think it really speaks truly to why I think the veterans should lead the way in the culture of civility. He said, by the dignity of your conduct, you will give one more distinguished proof of unexampled patriotism and patient virtue, rising superior to the pressure of the most complicated sufferings. Fancy old colonial way of saying, suck it up, drive on, be polite, treat people with dignity, and put a smile on your face. Listen, folks, we are all big boys and girls. And big boys and girls can disagree about big and important things. I can believe one thing, you can believe another thing. Somebody over there can believe a completely opposite thing. And we can all sit in a room and be polite and civil to each other with those different views. There's no need for name calling. There's no need for any of that stuff. Now, I haven't seen this on the blog. We've got a really solid community here, and that's why I think veterans can lead the way and show these goofy civilians that all they want to do is fight and yell, show them that it's okay for a conservative veteran to hang out with a liberal veteran. It's okay for a Christian veteran to hang out with a Muslim or a Jewish or an atheist veteran. That it's okay for us to all talk because we survived some stuff together that none of these folks have. And if we can get along together and if we can show that kind of civility to each other, then I think a lot of people will follow our lead. So hopefully y'all agree with me. Just think about it. And I would just encourage you that in your dealings online, if you feel drawn into a fight, just know the people watching this, the reasonable people seeing the name calling, they know what's going on. They know what's going on. They may not join in the fight, but when somebody calls you a bleepity bleep, leave it alone. Walk away. There's no need to respond. Let it go. Let it go. I'm trying to do that. I'm not the best at it. I'm not perfect at it, but I think that we as a community can lead the way. In any event, all right, if you want to voice your opinion on what's going on either side of the aisle, you know, I posted a couple of weeks ago the switchboard to Capitol switchboard. I meant to give you all a number that you can text your zip code to, and it'll tell you who your reps are. I'm going to put that in the show notes. And it's a really cool thing. You text your zip code, and then within seconds you get back, here's your U.S. senators, here's your congressmen, here's your state senators, here's your state congressmen, and then it's amazing. Their phone numbers are there. You can pick up the phone and call them and talk to them. Well, not the federal ones. They get a lot of calls. State ones, you know, you could probably talk to your state representative if you're from a smaller state like Arkansas. But in any event. All right, enough about that stuff. Let's see, where are we? All right, we're going to talk about the reasonable doubt doctrine. Well, look at there. There goes my phone. That should not happen. All right, let me get a sip of water. All right, so the reasonable doubt doctrine, also known as the benefit of the doubt doctrine. What is it? What does it all mean? There is this thing in the law called a burden of proof. Now, a burden of proof is what fancy lawyer word, some $100 lawyer word. Basically what it means is it's what you have to prove to win your case. And they say burden because only one person, one side, can carry a burden in a lawsuit or in a claim. And so if your side, as veterans do in most scenarios, has the burden of proof, then you have to submit certain things and prove certain things to a certain evidentiary degree. Okay, and we're going to talk about what that means in a minute. But we have, as veterans and claimants and survivors, the burden of proof in VA claims. So, back way before 2000, so 2000, the Veterans Claims Assistance Act, the VCAA, was passed. It kind of expanded the law, created some different duties that the VA owes to the veterans. It really was what we call in the law a liberalizing rule of law, because it kind of opened up the field to some new areas that are still being considered even 17 years later. Before that, our burden of proof, so prior to 2000, our burden of proof was that we had to show that after considering all the evidence, there was an approximate balance. Oh no, that's the new one. A claimant must submit sufficient evidence to justify the claim is well grounded. So it was a sufficient evidence, and what you're showing is not sufficient evidence of each of the elements. You're showing sufficient evidence that it's well grounded. So it was a pretty high burden of proof. That changed. There was one exception to that, and it was this benefit of the doubt rule. That changed in 2000. And in 2000, the Congress struck out that well-grounded claim basis. And what it said was, all it left was, after considering all evidence, where there is an approximate balance of positive and negative evidence regarding one of the four pillars, and they didn't say four pillars, that's me shortening the language. They probably should have. It probably would have been a lot easier for folks to understand if they just used my language, right? In any event, the veteran gets the benefit of the doubt. I would argue, and my arguments obviously were on the losing side, but I would argue that that language flipped the burden of proof to the VA, that they had to show a preponderance of evidence that there was not support for the claim. But that said, the courts didn't agree with that analysis. I never put that analysis before the courts, but they did not read it that way, and they read it instead as creating a new-ish burden of proof. And what that has largely grown to mean over the last 17 years is that here's what veterans have to prove. The veteran generally has the burden of proof and persuasion. There are legal nuances between the burden of proof and persuasion. The veteran need only prove that each element is at least as likely as not, right? They need to, this is another way that folks say it, is that the VA can only deny the claim if the preponderance of the evidence is against the claim, and if the facts are in equipoise. Another $100, that's actually a $500 word because lawyers won't even know how to pronounce it. But if the facts are in equipoise, the veteran gets the benefit of the doubt. So how does this all work? Because none of those words appear in the statute. If you go to read 38 U.S.C. 5107, none of those words that I just gave you that are the governing standards appear in the statute. All it says is, after considering all the evidence, there's an approximate balance of positive and negative evidence regarding one of the four pillars. The veteran gets the benefit of the doubt. Now, they say it in fancy legalese, but they never use any of those words. They never use preponderance. They never use at least as likely as not. They never use equipoise. None of that. It's all interpretation of that statute. And I'm not saying right or wrong. I'm just telling you what it is. So, a lot of veterans get, and frankly, a lot of attorneys, when they first start out, get kind of confused about this. So, where the VA went from there is they take the statute. They took 38 U.S.C. 5107, which basically said the language I just said. Your burden of proof is approximate balance of positive and negative evidence. Veteran gets the benefit of the doubt. And they wrote a regulation. So remember, if you've read the blog, you know this. And the link will be in the show notes about the 10 different rule books. You start out with the United States Code, USC. That's the law written by Congress. The next tier down is the CFR, the Code of Federal Regulations. That's what executive branch agencies use to publish the rules that interpret the statutes, right? Because remember, from all the way back in how a bill becomes a law in the branches of government, the Congress passes the laws, the executive branch executes them. That's exactly, and then the judicial branch interprets them. That's all the separation of powers is. And so the Code of Federal Regulations, or the CFR, is the executive branch's attempts to say how they are going to implement the law that Congress passed. And so 38 CFR's Title 38 Code of Federal Regulations 3.102 talks about this reasonable doubt doctrine. And what they've done something very crafty there. And it's so well entrenched now, I don't think it's going to change. And frankly, I read things a little bit differently than a lot of folks, so I'm definitely in the minority on this viewpoint. But what the reg says is undisputable. What it means is where I'm in the minority. But here's what it says, is that after consideration of all the procurable and assembled data, when there's an approximate balance of positive and negative evidence which does not satisfactorily prove or disprove the claim regarding one of those four pillars, reasonable doubt will be resolved in favor of the claimant. Now, what they've done is they've taken that language from the statute that says approximate balance. Approximate is not perfect balance, right? It teeters and totters back. And they basically flipped it into a reasonable doubt standard, which is, I would argue, a little bit harder standard. But where veterans and survivors and some early attorneys doing this work and some VSOs get confused is we read that and we understand the plain language, which says, if there's any doubt, the veteran gets the benefit of the doubt. And that's what we think, is that all we got to do is get enough in there to create the doubt that it could or could not be, and then we win. Well, I will tell you that that's not how the VA works, and it's a dangerous way to work your cases. So there was a case, and they always have these horrible names that are so difficult to pronounce, and so to this veteran, I apologize for butchering your name if I'm pronouncing it wrong. I'm going to break my arm, pat myself on the back if I got it right. So I'm covered either way. But the case was Hawk versus Nicholson, and it's 403 Fed 3rd 1303. It's a Fed Circuit 2005 case. The link, or at least the citation, will be in the footnote or the show notes. In that case, the veteran argued that the VA can't weigh evidence where the evidence was not contradicted or impeached. What did that mean? That basically meant when the veteran put information in there and the VA had nothing to counter with it or to say it's wrong or to prove it's wrong or to argue that it wasn't being interpreted correctly, then they couldn't weigh the evidence. There's nothing to weigh. It makes sense in a way, right? The Fed Circuit came down, and this is important, and that's kind of some of that stuff was a little bit too much information. What the Fed Circuit came down and said was, you're reading it wrong. To get to that benefit of the doubt doctrine, there has to be a factual predicate. What does that mean? You got to have two things. Two things have to be shown in the facts before you get benefit of the doubt application. The first thing that needs to be shown is that all of the procurable and available or assembled evidence was carefully reviewed. First thing. So once you've got that, then somebody has to find that there's reasonable doubt about how that evidence is interpreted or the conclusion that it comes to, right? And so that essentially means that to get to the benefit of the doubt, you have to have a decision maker at the VA decide that they've got all the evidence, they've carefully reviewed it, and there's doubt, right? Let me make a parallel that probably makes it a little easier to understand. Baseball. Who knows the tie goes to the runner rule? For those of you that don't know baseball, batter hits the ball, shortstop fields the ball, shortstop throws it to first base. If the ball gets to the first baseman's glove and the first baseman's touching the base, if all that happens before the runner touches the base, runner's out. If the runner gets there first, runner's safe, stays on the base, right? And then can get moved around to score. If they get there at the same time, if the ball hits the first baseman's glove at the same time that the runner's bag hits the foot, the umpire says it was a tie. And the rules say the tie goes to the runner. But you see what happened there in the middle is that the umpire has to call the tie. Now, we all know, and this is one of the reasons that we got this replay thing in baseball. I don't know which side of that argument you fall on. It doesn't matter. But we all know that that came about because there were some big problems with rules just like that being not applied because the umpire didn't believe there was a tie. And the video showed something different. And so we know that the subjective observation of the umpire on the field was not always accurate, and therefore the rule was never applied. Same exact thing is happening in the VA. The VA rater, the decision review officer, or the BVA judge has to look at all of the procurable, all the evidence you can get, and all of it that's been assembled do a careful review, and then, just like that umpire, they've got to decide that there's reasonable doubt. And how often does that happen? Not very often. Here's the takeaway. If you are arguing for application of the benefit of the doubt doctrine, which the court has told us is not your burden of proof, all it is a doctrine that breaks the tie in the evidence. If you're arguing that, you've already lost. You've already lost the case. What do I mean? Because somebody has already said that there is reasonable evidence in the record to deny the claim. They've also said there's reasonable evidence in there to grant it, and therefore at that point it gets resolved in your favor. But if you're arguing that, you have to concede to get there. You have to tell the rater, you have to tell the DRO, you have to prove to them the things that hurt your case. You have to show them that there's favorable or unfavorable evidence that could go against your claim, and that that's in perfect balance with the favorable evidence that supports your claim. And who wants to make that argument? Who wants to shoot themselves in the foot? There's a better way to do it. There's a much better way to do it. And here's the way you want to do it. You want to put in more evidence than you could possibly need, a preponderance of the evidence. And preponderance, in the law, it's got a very special meaning, and they teach us this in law school, is that, if you've got a scale that's perfectly balanced, a preponderance of the evidence is just enough to tip it in one side or the other. It's one feather past 50% is generally the easiest way to describe it. But I like to have a little bit more clear and convincing is a much higher burden of proof, and that's somewhere around, if you think of this as percents, like 90 to 95% certainty that a fact is true is clear and convincing evidence. That's not how the law works, but that's a good way to think about it. The preponderance of the evidence, they'll teach you it's just one featherweight past 50%, but I would argue it's somewhere in the 60 to 80% range. If you can get enough evidence in there to have 60 to 80% certainty that this fact is true, weighed against the other evidence, you've shown a preponderance. And if you can show a preponderance of the evidence, you're in a much stronger position, because then your argument is not, hey, BVA judge, there's some negative evidence in here, but it's in perfect balance with the positive evidence, therefore I get the tie. Instead, what you're arguing is you're saying, yeah, there's evidence in there that goes against my claim, but it's nonsense, it's bullshit, or it doesn't matter because I've got so much favorable evidence in there, I win. Take that baseball analogy. Would you rather be the manager of a team running out to the field to argue with the umpire and say, they got there at the exact same time, their foot hit the bag and the ball hit the glove at the exact same time? Would you rather make that argument? Or would you rather go out to the umpire and say, he was there 20 minutes before the ball got to first base? Are you blind? Now, that's not the way you talk to a judge. That's not the way you talk to a DRO. And frankly, the only reason you would talk to an umpire that way is if you're Earl Weaver. But in any event, you get the idea, and I'm doing that to illustrate the point, is that argue the stronger position. Now, to be sure, there are situations where you're not going to be able to get that evidence to a certain degree. We talked about a scenario last week where we talked about low-level flights going through the Agent Orange spray. How do you prove that there was actual exposure? That's a situation where you may have to kind of get caught up in the benefit of the doubt doctrine. But 99.9% of the time, you just don't want to go there. The better thing to do is to load that file up with evidence. And it's the 4 pillars. We've talked about the 4 pillars time and time and time again for the last 10 years. Eligibility for benefits. Service connection, to which there's 3 elements. Disability, nexus, right? And current or in-service event, current disability, and nexus. I've been doing this all these years and I get them mixed up there. And then the 3rd pillar is the impairment rating, and the 4th pillar is the effective date. So if you put a preponderance of the evidence, and we talk about 5-star evidence, I'm not going to go into that here, but a preponderance of 5-star evidence going to each of those 4 pillars, you have a super strong case. And you're going to be like Stephen S. at the beginning, where you take that and lay it out in front of the judge, and they can't help but grant your claim because you have so much information and you're arguing from a position of strength. You're not out there, Earl Weaver, kicking dirt on the umpire, arguing that they got there at the same time, that they're in perfect balance. You're arguing, I beat this by a mile, right? Okay. Enough about that. I want to talk to you about another case in the world of benefit of the doubt doctrine. It's the Ortiz case. And here's what happened in the Ortiz case. The veteran, this is a confusing case to me, so I'm going to look at my notes here. But The board in that case determined that the veteran's statements about what happened to his back in service, they said, you're not really credible. Now, credible, you guys know, you've been reading the blog, you know that credibility is a $100 lawyer word. Go look it up. It doesn't mean you're lying or telling the truth. It just means that the facts don't jive with each other, right? The board judge says it's not really a credible story about what happened in service, and so I'm not going to give your facts any weight. And the medical opinions that said that this event occurred and was your current disability is related to your military service, I'm not going to give them any weight either because they relied on statements from you that I found to lack credibility. So the veteran went into the court and argued kind of essentially what I was trying to argue earlier, was that when the board finds that even there's a preponderance of the evidence against the case, when that approximate balance teeters against you, that the benefit of the doubt doctrine still applies. And if you purely read that statute, I think that's the right argument. But that's not the way it's been interpreted. It's not the law. And until we can find the right fact pattern, I don't know that we're going to be able to challenge that anytime soon. It's a tough fact pattern. I'm not going to go into it here, but it's a tough one. So the point that I want to drive home is that the court came out and kind of laid down the law again and said, nope, that's not how it works. The only time you apply the benefit of the doubt doctrine is when there is equipoise, when there is an approximate balance between positive and negative, and there has been all of the assembled evidence and all the procurable evidence, and then the board has to find reasonable doubt. So if you're arguing benefit of the doubt, it sounds like you're getting an advantage. It sounds like you're getting an edge, but you're not. It's basically the last dying effort to save a claim that's going down. The better thing to do is to plug the leak, get your C file, find out why they're denying it, and plug that leak with 5-star evidence that just overwhelms the case file. And we're going to talk about how to do that in Tuesday's webinar. We've got another webinar coming. We got an evidence ebook up there. I'm going to teach you all about 5-star evidence in that ebook. I'm going to teach you about it in the webinar coming up in a couple of months. You know, there's a lot of stuff on the blog about how to build lay evidence. Vets like Stephen S. and many of the other vets that you see on the testimonial page have used those posts to figure out how to load their file, how to plug that leak in their claim ship. That metaphor really doesn't work, does it? Because stuffing paper in a hole, the water's still going to come in, right? Anyway, you get the idea. If I could impress upon you to take one thing away from this discussion, it is completely get out of your head the idea that the benefit of the doubt doctrine is something that works to your advantage. In the end, it does. In the end, if you truly have that tie goes to the runner, you do have that edge. But you don't want to hang your hopes on the benefit of the doubt doctrine because that means you've already lost the case. That means there's either a preponderance of the evidence in perfect balance, there's good evidence that goes against your claim, just as much as there's good evidence that goes for it. And then you've got to rely on a board judge or a DRO or a VA rater to say there's reasonable doubt. And I know a lot of these board judges, and I know a good number of DROs, and I like a good number of them, and there's a couple I don't like. It is what it is. But it is really, really rare that somebody at the board, at the DRO conference, at the rater, is going to find reasonable doubt. Why? A lot of reasons. It's hard to argue to your boss. If you have to end up paying $100,000 of past due benefits, then you have to go to your boss and up 2 levels of chain of command to get that approved, that past due benefit approved, to argue to them that this guy should get all his past due benefits. We should take that out of our operating budget or out of our discretionary budget and pay this because I have a reasonable doubt. No. They're going to cover their own butts and they're going to go against the claim. Put in a preponderance of the evidence, 5-star evidence as to each of the 4 pillars of your VA claim is the best way to do it. Best way to do it. Even though that's not the legal standard, it's way beyond the legal standard, so if you do it, you win. And then all this benefit of the doubt stuff goes out the window. All right? Confusing stuff. But when it clicks, when you get it, then all of a sudden things start popping in your case because you're like, I get it now. When you take one small claim, like a tinnitus claim, or a hearing loss claim, or a foot claim, a foot injury, or if you take some other small case first, and I'm not saying break your cases up like this, but if you win a small one first, or frankly, even if you win a big one, using the information in the blog to do that, then you start seeing what that really truly means. And it was probably a little bit easier for me to see it because at the point that I started doing this work, I had a few years work, trial work doing employment law. So I knew how to prove a case. I knew what evidence was. I knew some pretty nuanced stuff, nowhere near what a 20 or 30-year attorney knows, but certainly a lot more than a lay person does. So I could see it a lot quicker. You guys have the disadvantage that you're generally only in your claims, and so it's a lot harder to see. And so that's why you want to really just get in there and focus hard on that one thing. If you could do that one thing, it makes the world of difference. It's actually several things, and I call them the 8 steps to improve your VA disability claim. But it starts, recognize that you're the solution. Get your C-file. Learn the law. Prove the 4 pillars of your claim with a preponderance of 5-star evidence. And then we go into using the claims process in your battlefield, designating a representative if you choose, and protecting your survivors are different things. But if you focus on those things, those first few things that I mentioned, you almost can't help but win unless you've got one of those really challenging claims that the VA is just going to dig their heels in on. Military sexual trauma, particulate matter claims, Gulf War syndrome, a lot of traumatic brain injury cases, more and more PTSD cases, although I'm not going to speak to all of them. But they start digging in their heels. Agent Orange Thailand, Agent Orange Korea, Agent Orange Guam, Okinawa, Agent Orange Fort Detrick, Maryland, right? They're digging in their heels. Well, that is the 4th time that somebody from Houston has called me, so that's unsettling. All right. Let's see, where are we going? Bang, bang, bang. All right, we are going to take a sip of water, and then we are going into the lies that the VA tells survivors. How are we doing on time? Oh, we are good. We got plenty of time. All right, I have, just so you guys know, my middle boy has his first baseball game tonight. It's a scrimmage, actually, but he is a freshman in high school, and he made the varsity baseball team at second base. So I'm not missing that game for my life. I'm really proud of him. He's done some cool work, so I'm going to be jetting out of here really quick after this. Those show notes may not get up until later tonight. After that game, I've got to go for a run. I'm running a half marathon, and you'll find out why at the end of this show. So bear with me. These links may not get up there until later this evening, or maybe even early tomorrow morning, but hopefully I'll get them up there later this evening. In any event, let's talk about the lies that the VA tells survivors. So if it was really an emergency, they would have left a voicemail, right? In any event, my grandmother, you guys know this. You've heard this story. I've told it a million times. It's probably, you're like, oh, God, here goes Chris with the grandmother story. She is a surviving spouse of a World War II veteran. My grandfather fought at the Battle of the Bulge. Horrible, horrible, nasty battle. A lot of folks did not make it through that battle, and the folks that did came back pretty bad shape, physically, mentally. My grandfather came back and died of his wounds that he suffered in that battle. My grandmother at the time had 5 young kids, went into the VA and said, I need help. I heard there's this thing called the widow's pension. What they told her was, no, not available. Take your husband's Social Security payments for death, and that's better than anything you'll get from the VA, and be happy. That's what they told her. And she had 5 kids to raise. There wasn't near the information that was out there 50 years ago that there is today. It was more than 50 years ago. But you get my point. Back in the 50s and 60s, there was not a whole lot of information like this out there. So you believed what the VA told you. People were coming out of that World War II era believing their government bureaucracies. Turns out, it was bullshit. It was just nonsense. After my grandmother passed away, I got an opportunity to look into my grandfather's file. She would have been eligible for a lot of years of dependency indemnity compensation. Probably a couple $100,000 over a couple of decades. That would have changed her life because she died. And I mean this with all literalness, she did not have 2 nickels to rub together. I don't even think that there was $1 in her bank account. She had a very, very rough time. She was one of the sweetest people you ever want to meet. Actually, she was kind of mean sometimes, but not to us. We called her Grambo. Man, I want to tell the Grambo story, but I can't do it because I got to keep going. So somebody remind me someday It involves George Brett, so I'm building up a lot of suspense on this one. But anyway, that kind of pissed me off when I learned that, because you got the VA lying to a survivor. It's one thing to lie to a veteran. You know, as I told you, 2,500 years of history, we're expecting to be cheated out of our benefits. It's kind of part and parcel of the territory of going to war, serving your country, coming out and becoming a veteran. You're going to get cheated by the government. It's just the way of life. But don't mess with our spouses. Don't mess with our kids. Take care of them, right? You think that's the way it should be? No, they get lied to all the time. All the time. That's why one of the steps of the 8 ways to improve your VA disability claim is taking care of your survivors, because there's things that you can do now today as a veteran that ensures that they can't screw with your surviving spouse or your kids or your adult disabled children. Here's the deal. This is happening a lot, and I will tell you the number one target of opportunity for these lies are Vietnam, the surviving spouses of Vietnam veterans, Vietnam-era veterans that served in Thailand, that served in Korea, or that served in the Republic of Vietnam. This is the number one target of opportunity for these lies. It's the same scenario I just told you with my grandmother, is that the spouse, the surviving spouse, goes to the VA and says, my husband, or in some cases my wife, and that's happening, we're seeing that a lot with OEF and OIF vets, is that the wife goes in and says, the veteran passed away, or the husband goes in and says, my wife passed away. And the VA, they think it's a VA employee. What it really is a VSO, a veteran service officer from an organization, tells them, and I'm not saying it's all organizations, there's some that don't do this, there's many that don't do this. There's a couple that do it notoriously because of a lack of training, but a lot of folks, the point is, think that these VSO representatives are actually employees of the VA, so they give it a little bit of extra credibility. And the first lie that the survivor is told is that if your husband or your wife, the veteran, was not getting medical care at the VA, you can't file a claim. Who thinks that's true? No. There's no such thing. There's not even a rule close to that. What that is, as best as I can figure, is you've got a VSO that the only way that that VSO knows how to prove a claim is by calling the VA Medical Center, getting some records, and giving them to the VA and letting them do the hard work. And if that's the kind of VSO you've got on your claim, you need to drop that shit like a hot potato, because there are better VSOs out there that will actually work your case, take interest in your case, be curious about your injury enough to research it, ways to prove it, and do work, and not just dump medical records. And so what that VSO who tells a survivor that has done is he has let him or herself believe that you need VA medical records in order to win a VA claim or file a VA claim, as one veteran in Virginia was told, one veteran's surviving spouse in Virginia was told. It's not true. So if you're a veteran, let your surviving spouse know. Take an index card and write these things down and put them in a safe deposit box. If you weren't getting VA medical care, your surviving spouse can still file surviving spouse benefits claims. And there's 3 big ones on the benefit side. There's a lot of them out there. A lot of them, from cemetery benefits, from final death medical reimbursement. But the big ones that I'm talking about, because they're the high dollar ones that change lives, are accrued benefits, substitution, and DIC. I'm not going to go into detail on them here because we could spend hours, and we will spend hours on those topics. But for right now, take an index card out, put this in the safe deposit box, and say, just because I didn't get care at the VA doesn't mean you can't file a claim. File a claim. 21-534 is the form you use, right? Well, not if you go to a VSO in Tennessee, where the VSO will tell you VA form 21-534 is no longer being accepted by the VA for accrued benefits and DIC claims. I don't even know where you get this stuff. I don't even have any clue where that comes from. 21-534 is still 100% valid. It's still a good form. Use it even if it wasn't a good form. You can still use it to express exactly what you want to file. If you submit that 534, if it's an invalid form, they're going to come back and say, we got your claim, you used the wrong form, here's the right form. It may take them 9.5 months to do it, but use the form. It's the right form. 21-534, there's an EZ form if you want to fill out the shortened version, but that's how you request DIC accrued benefits from the VA as a surviving spouse. If you're within a year of your spouse passing away, there's a form that you can use. I don't remember the number off the top of my head here, but there's a substitution form where you can substitute as if you were the veteran. So use that form. File it. There's a little known rule out there that if you apply for Social Security death benefits, that it also is a claim for VA death benefits. I wouldn't want to be in a position of arguing that rule because I just don't know how thorough the Social Security Administration is in keeping records. I don't do those cases. The only interaction I have with the Social Security agency is when we request a file for one of our clients, or every year when I get that goofy form in the mail that tells me how much I'm not going to get when I'm not 75. So just file a claim. File the claim, use 21-534. Another lie, another myth that these folks will tell you is that if the veteran didn't make a claim while he or she was living, the survivor can't make a claim. Who thinks that's true? Yeah, it's not. It's 100% false. You have an opportunity to file a claim for service connection of the cause of death of the veteran, regardless of whether or not the veteran filed it in their lifetime. The reg actually says that you're entitled to benefits, to DIC, for benefits that were or should have been granted during the veteran's lifetime. And that right there has been interpreted to mean that you can file a claim for service connection of cause of death even after the veteran's passed. It's a narrow window, and it can be challenging, but you can do it. Another lie that they tell, and this is the one that boils my blood, and I heard it directly from an Albuquerque regional office DRO, and it's one of those times where I said some stuff that I regretted. I should have bit my tongue and just wrote it down and put it in the shredder and let it go, because we ultimately won the case. The myth, the lie, in this case the utter nonsense, is that a survivor cannot file an application for benefits unless the veteran signs it. Think about that for a minute. And think how a deceased veteran is going to sign a form. Yeah, it's nonsense, but I've heard it come out of the Albuquerque regional office. We just had a story where it came out the last 2 weeks. I've heard this story twice from Tennessee and from Virginia VSOs. So, and we know which ones they are, and we're working those angles. Probably we'll have to wait until we get these claims for the survivors out of their book, basically, hopefully either granted or into appeal phase, and then they're off the VSO's books, and then there won't be the retaliation that you get when you call some of these incompetent VSOs. Now, I just want to be 100% clear, folks. There are some rock-solid, awesome VSOs out there. Go online, get my How to Choose an Attorney ebook. It's free. The ebook is 100% free. If you want to buy a copy of the paperback book, you can go on there. There's a link that'll be in the show notes. You can buy it. It's a couple of bucks, but that's all the publisher that does the hard copy of that book. I don't have any control of that. Use the questions in there that I tell you to use to ask when vetting a lawyer. Use those questions when choosing your VSO. Same questions, because they're going to tell you whether you got someone that knows what they're talking about, that's going to be dedicated to your case, that wants to see success for you, that wants to help you, and you're not just going to be a number or a file in their cabinet while they're out, buying new hats for the bar or whatever VSOs do with those yellow hats. Sorry, yellow-hatted people. I do not mean to offend. I'm just making fun of yellow hats today. In any event, there are some awesome VSOs out there. I am not saying that all VSOs are incompetent, but there are a few out there that do not need to be doing this work. And the ones that we heard about that are telling veterans, survivors, that the veteran needs to sign the form in order to apply for survivor benefits, they need to move the hell down the road. They need to just move on down the road to another job. That is flat out not true. And if you are told that, contact me right away, because I take action on those quick. All right, here's another one. DIC has an income qualification component. The way they say it is you make too much money to get benefits as a survivor. That's partially true. There's one type of benefit called the non-service connected survivor's pension, or in the old day it was called the non-service connected widow's pension, that is need-based. All right, and that need-based base is, I think it's $7,094 a year after deductions, and it's convoluted. You got to go through this whole process of offsetting debt, but you basically you got to be dirt poor, and that is only going to give you the difference between your actual annual income and $7,094 or whatever it actually is. So if you make $5,000 a year, the VA is going to give you $2,094 a year. It's not a lot. In some cases, for really, really bad off survivors, that benefit can be a huge difference. And the VA knows that, and they move quick on those cases. The non-service connected pension for veterans and the non-service connected pension for survivors move pretty quick because they know that in those cases, that money is life or death. But for any other survivor's benefit, DIC, accrued benefits, substitution, you can be making $1 million a minute. $1 million a minute. You could be making $20 billion. You could own Goldman Sachs, Wells Fargo, Bank of America. You could own all of them. You could own all the Facebook stock in the world, sell it every day, buy it again, sell it every day, make all that money, and you're still eligible for survivor benefits. Now, if you're buying Facebook stock today and selling it tomorrow and then buying it the next day, then you're getting into the wash sale rules and you're probably not going to make any money. But my point is there is no income requirement for dependency indemnity compensation, or DIC. It's about $1,200, $1,215 a month. There's some aid and attendance that can be added onto it. There's no income requirement. There is no income requirement for accrued benefits. Accrued benefits are benefits that should have been paid to the veteran during the lifetime in a pending claim or appeal. If you got a pending claim or appeal going, survivor can step into that under substitution theories, or even 1 year. I think it's up to 1 year they can jump back in and accrue benefits if it's prior to the substitution regs, but they can get the benefits that accrued during the veteran's lifetime. There is no income requirement or limitation for those benefits, only for the non-service connected widow's pension. Here's another one, and this one is told a lot to surviving spouses of veterans that served during the Vietnam era and Korea, Thailand. That your husband couldn't have been exposed to Agent Orange because he didn't serve boots on the ground in Vietnam. And we've got a case out of Winston-Salem regional office where it was almost months after the rule came out that said, back in 10 or 12, where they said that we're going to concede exposure along the perimeter for dog handlers, MPs, and a couple other scenarios. They were going to concede exposure. Right after that came out, enough time for it to circulate through the system, they told our client that she was not eligible because the VA doesn't believe that Agent Orange was used in Thailand. She showed them that fast letter, and they still said, no, that's not right. So if somebody tells you, as a surviving spouse, that you're not eligible for survivor benefits because your Vietnam-era husband, or in some cases your Vietnam-era wife, did not get exposed to Agent Orange in the Republic of Vietnam, that you're not eligible to survivor benefits because of that you're not eligible for survivor benefits because of that, they are wrong. Don't believe it. It is nonsense, and it is a good signal that you should not work with that person because they don't know what they're talking about. I can forgive that one a little bit because a lot of times some of these bigger VSOs, the training money doesn't always trickle down to the folks that are on the ground, and so they find out about these things. Sometimes it's a year or two down the road, and that's just a fact of life. Hopefully there's some VSOs. I know there's a lot of VSOs that watch this blog. There's a couple of VSOs that I work with to keep them current on the law. I'm trying to come up with a system that we can have something a little bit more solid for VSOs, but a lot of times that information does come out, and there's some real good ones that do circle back around and say I was wrong. It happens, and there's good VSOs out there. But there are some folks out there that they believe in their head that things are as they were in 1972, and they're not going to change. So if somebody tells you that there's no Agent Orange exposure rules for serving on a Royal Thai Air Force base during the Vietnam era, and that if your husband or wife was one of the veterans that served on one of those bases, you don't get an eligibility for survivor benefits because they didn't serve in the Republic of Vietnam, just know that you're either dealing with somebody that doesn't know what they're talking about or that's not keeping current on the law. because that thing is 7 years old or 5 years old. I can't remember if it was 2010 or 12 that rule was issued. But either way, it's old enough now that everybody that does this stuff day in and day out should know about it. All right, the other one that they tell you is just, well, this is the one I told you about at the beginning. Just take the veterans' Social Security death benefits because it's more than your survivor benefits will be, so just take it and be happy. And that is told a lot. And the only benefit that the Social Security disability benefits are probably more than are the non-service connected pension benefits. But that's not what we're talking about. We're talking about DIC and we're talking about accrued benefits. And those are pretty significant claims. DIC, there's 3 ways to prove it. I'm not going to go into all of them here. Generally speaking, when a veteran dies from a condition that was or should have been service-connected during their lifetime, under certain scenarios, you're eligible for dependency and indemnity compensation, which is a monthly stipend that you get. Now it's currently $1,215 a month, I think. It's over $1,200 now. It might be $1,234 or $1,243. It's somewhere up there with the cost of living changes recently. But it's a significant amount of money each month, and that's paid until the day you die or until you remarry. That's pretty significant. There is no Social Security death benefit that's that big. Accrued benefits. Some of these cases for accrued benefits, there's a lot of past due. A lot of past due out there. There have been a couple cases my firm has handled for survivors where we have recovered $250,000 or $350,000 in past due benefits for those spouses. That's a lot of money. Way more than Social Security death benefits, right? Accrued benefits occur when you've got a pending claim or appeal at the time of the veteran's death. It used to be the old rules. The survivor could claim accrued benefits within 1 year of the veteran's death, and then they could finish proving up the claim. They were limited to what was in the file at the time of death. The new rules recognize the problems with that, and it's called substitution. So within a year after the death of a veteran, a survivor can step in as if the survivor was the veteran, can add evidence to the file, can add new arguments, can handle that claim as if they were the survivor. So if somebody tries to tell you that accrued benefits are not going to be more than Social Security death benefits, again, turn and walk away. Now there's a case if your accrued benefits were 20% for hearing loss and tinnitus and a couple of scars for 1 month because the claim was filed 1 month before the veteran passed. Maybe that non-service connected pension is going to be more than that, but it's rare that you see an accrued benefits case that makes less than Social Security death benefits. So that's nonsense. In any event, the last one that they tell to surviving spouses is that the claim died with the veteran. And that is 100% lie. 100%. Don't believe it. We've talked about a number of scenarios in the last, 30 minutes. Number of scenarios where a surviving spouse can continue a claim, can continue appeal, can start a claim after the veteran's passed. The veteran's claim does not die with them. The only time a veteran's claim dies with them is when they do not have an eligible survivor. And there's several kinds of eligible survivors. Spouse is an obvious one. Another are indigent parents. And I'm not going to get into that as complicated math rules, and it's going to take this video and into a long sort of conversation. But just know that indigent parents, in some cases, can get that survival benefit. And certain children over the age of 18, and they call them adult helpless or helpless adult children. I hate that phrase. I hate it because I know a couple of these folks. We have, as one of our clients, the 62-year-old now, I think, son of a World War II veteran who passed away several years ago. And he has a cognitive impairment, cannot take care of himself, needs daily help with his daily living activities, but he is not helpless. And it's demeaning to call him that, I think. So I really, truly wish that the VA would just call that adult disabled survivors. adult disabled dependents, something other than helpless adult child. For the love of God, we don't need to insult people the way we name benefits. But that's another rant for another day. There's the only way that a veteran's claim dies with them is if they do not have an eligible survivor. And in some cases, there may be a way around that. But I'm not going to get into that here. Certainly not going to get into that too much because it's a really rare set of circumstances. In any event, that kind of wraps up the show for today. I want to tell you guys what the coupons are for the week. So listen, I told you about one earlier in the show, veteranslawblog.org/4pillars. Through the weekend, $49.95, you can get access to the live webinar on Tuesday, Proving the 4 Pillars. We'll talk a lot about some of the stuff we talked about in this case here today about how to prove that preponderance of the evidence so that you don't have to argue benefit of the doubt. The second one is, where did it go? veteranslawblog.org/annual. We're not doing a coupon this time. We're actually going to just have a site. So type that in, veteranslawblog.org/annual. Takes you to the annual membership page. And if you get an annual membership for the next week, from now through the end of next Thursday, so I guess it's really only 6 days, now through the end of next Thursday, we've reduced the price $20 for an annual membership. So jump on in now. It's not going to be that low again for several months. I do a 4th of July sale. I'm probably not going to be able to afford to drop the price down after that, so jump in while you can on that annual membership. In any event, I want to also ask y'all a favor. You guys know that I run. You guys know that when I do these big races, that I usually run them to support some nonprofit. And the nonprofit usually falls into one of a couple categories. And we're either going to have a veterans nonprofit, or we're going to have one that supports special needs children. Those are two groups of people that are pretty near and dear to my heart. I am running a half marathon here in Little Rock. There's the city of Little Rock right behind us. I'll be running through those streets for a half marathon on March 5th. I am trying to raise money for an awesome school here in Little Rock that does some awesome things for kids with special needs. So early childhood intervention, ECI, is crucial for kids with a diagnosis of Down syndrome, diagnosis of cerebral palsy, childhood autism, any number of Fragile X syndrome, Edwards syndrome, any of these conditions, and there's hundreds more there, hundreds more. Early child intervention with these kids is crucial to giving them the ability to survive as adults. Because for any kid, the first 3 years of life are crucial to learning vocabulary. What you learn in those first 3 years of life creates the neuron set that feeds your brain. So if you prop up in front of the TV for 3 years, you might become a really good actor. That's kind of joking. I don't mean to joke about that. I really just want to drive home the point that those first 3 years are important. And then when you have a child with special needs, it's more difficult to get that kind of education and learning in that needs to happen in those first 3 years because you're dealing with other issues. Teaching them how to eat, teaching them how to move, teaching them how, in my son's case, we had to teach him how to crawl. And now the little booger is running everywhere and you can't hardly keep your eyes on him, thanks to a program very much like this one. So early childhood intervention works, and it works miraculously in getting kids with special needs set up for success in adulthood. There's a school here in Little Rock called the Access School, and they do all ages. I think they go all the way up through high school, and they even have young adult therapy programs, but it's a school. And the early childhood intervention program is phenomenal. It does amazing things for these kids. I know some of the kids that were in it. I know some of the families. I know some of the folks that work there. That's one of the reasons that I'm pushing for donations to this group to support my run for them. I'm going to run the Little Rock Half Marathon to support the early childhood intervention courses or program at the Access School. I'm going to ask you guys if you would help and donate a couple bucks. I know times are tough for a lot of us. If you have, $5, $10, $15, $20 or more laying around, if you would donate it, it goes directly to the school. I think if you put a credit card online, it takes like 2 or 3% off for the credit card processing fee. But then it all goes directly to the school. None of that money passes through me. I don't even touch it. The only thing that I see is your name, your address, and your email, and I'll make you a deal. between now and the day before the marathon, March 4th, so today and March 4th, you make a donation to support my run, and I will send you a coupon code to get that same amount off your next purchase at the Veterans Law Blog. That's the best I can do in terms of we don't have cool coffee mugs or any sort of that stuff. That's what I'll do. So you donate $25 to my nonprofit. The Access Group is not mine. It's the one I'm running for. You donate $25 to them, I'll send you a coupon code to get $25 off any purchase at the blog. You buy $100, you spend $300, whatever you spend, I'm going to send you or you donate that, I'm going to send you that coupon code. So it may take me a couple of days because that information, I get the report about who donated, their contact information, it's behind a couple of days. So I will privately send you an email with that code. I've got to set it up each individually. But if you do that, I will get you a code. You can use that to make a purchase at the Veterans Law Blog. Between now, you can make the purchase anytime. I'll make the coupon code last forever if you want. But whatever you donate in support of my run, I'm going to give you that much of a discount on your next purchase at the Veterans Law Blog. So how do you donate? Go to this website, irun41.org. IRUN41.org. It stands for I Run for One. Go there, and you'll see the information about this run, and there'll be a donate button. You can click on it. Donations are going right now. They're going through a site called Razoo, and that's so that the money can go right from your bank to the Access Group, and you're supporting early childhood intervention programs for kids with special needs. It's crucial stuff here. You are really, I swear you guys are changing lives with this stuff. $25 goes a long way to creating therapy, to paying therapists, to getting folks in there, and it's just amazing. I really would love to get one of these kids on here to show you the difference. Maybe we can talk to them about getting a video or something to show. But anyway, I'm babbling now. I got to go see a baseball game, and then I'm going for a run. Please donate if you can. Use those coupon codes. If you forget what they are, they're at www.veteranslawblog.org/coupons. Any live coupon code, and there's always something going on. Any live coupon code you see is there. Submit your questions for the next episode of the Veterans Law Blog Livecast at veteranslawblog.org/Facebook Live. The show notes will be posted later this evening, and this will be live on the website by early next week. So, had a great time with y'all. Thanks for jumping in. And remember, let's lead the way on civility in our new culture of civility. Let's show people. Let's lead the way and teach people how to be civil to each other. All right? Y'all have a great weekend. Take care.